Bowen Turner became the poster boy for the problems in the South Carolina judicial system when, after being charged with the rape of 3 separate teenage girls, he was granted a misdemeanor assault plea deal by solicitor Bill Weeks. Today, attorneys representing Turner's victims appeared before the South Carolina Court of Appeals to argue that victims have a right in South Carolina to be heard prior to the acceptance of plea deals. Here's what they said in court.
Our state constitution promises to protect victims' rights to justice and due process. It also promises victims fairness, respect, and dignity. We're here today because those promises were broken when the lower court refused to hear from the victims before it accepted Mr. Turner's guilty plea.
I'll just go ahead and put this out there for everybody. I have grave concerns about the way the 2 solicitors' offices handled this below. But that's a different branch of government, as you well know. As I read the transcript, it seemed that the court accepted the plea and then heard from at least 2 victims' families, fathers, I believe, and then actually increased the probationary period. I didn't think this was a probation case, but I wasn't the trial judge.
I do believe what we're asking for is for the court to establish a procedure which requires lower courts to hear from victims before accepting or rejecting a plea. And that is the critical issue before this court. Now, you did reference the fact that the court heard from the victim before sentencing, but I submit to this court that while it is the practice in our trial courts to smush the plea hearing and the sentencing hearing together, those are actually 2 different processes. And our Constitution has specific provision that grants victims the right to be heard at both of those stages.
It does, but it gives us no mechanism to enforce that. So give me some suggestions that may or may not be within our power and authority to do, but maybe somebody else's.
After today's hearing, I spoke with victim Chloe Bess about what she would have liked to say to the judge had she been given the opportunity to speak to him prior to his acceptance of the plea deal.
If I was given the opportunity, I would have hoped that they would have heard me out, and maybe some things would have been different, because as of Sarah said, when you're getting charged with a felony and then it gets brought down to a misdemeanor and I basically have no say in that, it just makes me feel walked on, and nobody's listening to me. So, to feel like that before coming into the court, and then to have it play out that way. I mean, it just really is, you're beating me like a dead horse. So it's an awful position to be put in, but that's why we're here today. And that's why we're going to keep going, because I refuse to be defeated by this.
Victims' rights attorney Sarah Ford gave me her legal perspective on why she believes it's important that victims be heard prior to the acceptance of a plea.
In a situation like this, where a victim has been victimized in the way that these victims were, the defendant was charged with criminal sexual conduct and then is allowed to plead to a misdemeanor. It is essential that victims are heard before that guilty plea is actually accepted. Otherwise, the court is not hearing the entirety of what happens, and oftentimes many of the facts are brushed over by the solicitor in order to make it acceptable for someone who was originally charged with violent rape to allow them to plead guilty to assault and battery with no sex offender registry. It is in the best interest of the public, it's in the best interest of victims for our courts to hear the entirety of the facts, to hear from victims at the appropriate time. And we believe that appropriate time is before that plea is accepted. Otherwise, it makes a mockery of the constitutional amendment that the citizens of South Carolina want, what they have ruled on, what they have voted on.
And as you heard in the clip, not all of the judges on the Court of Appeals were convinced that they were the right people to be remedying this issue. So I spoke to attorney Malia Bowers-Jefferson about what she believes the legislature should do if the Court of Appeals does not rule in their favor.
If the court decides that it's not the appropriate venue to provide a remedy to victims, then the legislature needs to act to make sure that the voice and the will of the people of South Carolina is something that is actually heard. The
amendment for victims' rights was overwhelmingly approved. It is the public policy of the state, and legislators, in my opinion, would be derelict of their duty if they did not put forth rules that allow for true practical enforcement of those rights.
But it wasn't only the victims making motions today at the Court of Appeals. An attorney representing Bowen Turner argued that he had been improperly placed on the state's sex offender registry, which he was automatically placed on after violating the conditions of his parole. Here's what he said in court.
Our objection is to the sex offender registry. But what this case came down to at the plea was condition 11 here in a series of sex offender conditions dealing with drinking alcohol. And it's a dead serious case, and I don't mean to be flippant in any way, but I think this comes down to is almost as if at one point near the end of this plea where the plea judge could have said, if you so much as sip a beer, you're going on the sex offender registry. And I would think and I would hope we would all think that was absurd, but I submit that's what happened in this case.
Well, it may or might not be considered a lot of absurd. It's the context of the plea in which it is taken, as I see it. So I hear you on that. But I think what I was looking back through was I happened to just pull up what the assistant solicitor that was there that day explained when he was presenting the plea. Sex offender registration will be held in abeyance. If the defendant successfully completes all probation requirements, he would not be required to register as a sex offender. If he violates the terms of probation and has a YO sentence activated, he will be required, period. If the defendant violates the terms of probation and does not have a sentence activated, a further hearing would be held to be determined whether he has to register or not. Why is that not pretty dispositive in explaining the plea as it was presented?
And after those arguments, I spoke with victim Chloe Bess once more. Here's what she had to say about Bowen's bid to not be put on the state's sex offender registry.
At the end of the day, he is a risk to reoffend. I mean, he's done this 3 times. So I really don't know how they can't see that. And then, you know, from my understanding, the conditions of the bond were pretty black and white. And so you violate that, these are your consequences. So I'm not sure where the confusion is on, you know, why they're not wanting him. I mean, I guess they don't want him on it, of course, but you did what you did. Actions have consequences, and up until this point, I mean, his actions have had almost 0 consequences. So, you know, I think it's absolutely ridiculous, but I mean, they can certainly try. They have the right to. And so we'll just see how that goes.